Against the death penalty, and the Parliamentarians for Global Action's launch event for our manual on how to work with parliamentarians to abolish the death penalty. So I am sharing the link in the description, so in the chat and the discussion. So for those who do not have access to the manual, you can download it on our website. My name is Bronwyn Dudley, and I'm the program manager at the World Coalition. I also coordinated the drafting, structuring, and translation of this guide, and I will be monitoring this event. The purpose of today's event, as I mentioned, is to launch this how-to manual, but also particularly to allow for discussion in identifying methods of meaningful advocacy for the abolition of the death penalty with parliamentarians. This particular manual had been requested as, or identified rather, as a necessary advocacy tool by the World Coalition membership following a poll in 2018. And it was an area that had been recognized as a meaningful way to be able to advance work towards abolition of the death penalty. But there were maybe gaps in knowledge or necessity in improving how to go about doing that. So we decided to draft the manual with Parliamentarians for Global Action and offer it as a tool, as a meaningful way to move forward with collaborations with MPs and senators and congresspersons. As such, it's my pleasure to introduce our speakers today. We have the Honorable Dorcas Sibanda, who's the Member of Parliament in the Republic of Zimbabwe. She is also chair to PGA's national group in Zimbabwe. She has been having some very complicated technical issues in joining us today, so we hope that she'll be able to join a little bit further on in our discussion. We also have with us Ms. Noor Raja, the team lead of the Policy and Advocacy section of the Justice Project Pakistan, an NGO and member of the World Coalition who works with vulnerable persons incarcerated in Pakistan. So thank you for joining us. And lastly, we have Ms. Frederika Schweighoferova, who's the senior legal officer to PGA and a colleague in the creation of this guide. So with any further ado, I will pass the floor to Frederika, who will give us an overview of the how-to manual and its added value in the fight for abolition.
Thank you very much, Bronwyn, and welcome to everyone. So I'll be trying to share my screen to share with you the guide so I can go through it and maybe introduce it as I scroll down. Of course, the document is available online and Bronwyn has shared the link. So of course, feel free to open it on your own. Okay, I may not be able to share my screen actually. So perhaps I will invite everyone to open the guide in such case, if that's possible. Okay, thank you. Okay. Apologies for this. It's actually not really working for me to, yes. Hopefully, yes, maybe. Let's see. Well, maybe in that case, okay. Well, unless that would be problematic, maybe I would then invite to open the guide on your screens, because for some reason I'm not really allowed to Okay. Well, in any case, so as Bronwyn has already introduced the guide, it has been drafted in collaboration with the World Coalition Against the Death Penalty and PGA. And it should also be considered as a companion and already a resource that was already published by a World Coalition in 2014, which was a parliamentary resource. So that was focused on the parliamentarians, whereas this guide is targeting civil society and provides them with entry points and advocacy tools how to work with parliamentarians. I would be, yes, perhaps that would be useful, Daniel, if you could share, but then I'll just go quickly through the guide, so that may be actually difficult to follow. So the guide consists of two parts. The first one introduces who the parliamentarians are and their functions, and the second part dwells a little bit more into the concrete advocacy tools and the way how to work with parliamentarians. So, of course, the parliamentarians, the reason why they are crucial in the role of the abolition of the death penalty, I mean, it doesn't necessarily need to be further explained, but perhaps just to mention their key four roles or responsibilities that actually make them one of the key actors in the area of the abolition of the death penalty, is that they can make policies, and this is of course done through debates, through the discussions they have at the parliament, and of course also through their concrete actions they can take with their peers. So they are the key actors in policy making, or one of the key actors. Of course, one of the ways how to make policy is also through lawmaking, which is another one of the key responsibilities of parliamentarians. And through lawmaking, they can, of course, through a private member's bill, they can have direct and tangible results and impact on the abolition of the death penalty. So this could be done through, of course, starting or ranging from securing higher legal standards for the process, and also in basically in all the proceedings of the capital cases. But then, of course, it goes further to reducing the scope of the death penalty, of the application of death penalty, passing an official moratorium on executions, and of course, ideally, private members' bill to abolish the death penalty whatsoever. But of course, they can also propose any amendments to the legislation which is conducive to achieving this objective. And one of them, for instance, is ratifying the relevant international instruments, and also promoting the creation of regional treaties that actually would aim for the same objective. This is very important to realize, because civil society can actually request parliamentarians to help in preventing the return of death penalty as well. So let's say even in countries that have already abolished. So whether there is a threat, civil society can also request, or maybe through their advocacy work, achieve that the parliamentarians would vote against a bill that would reinstate the death penalty, or that they would serve as an opposition in any public debates. As another key function of parliamentarians, they are responsible for oversight. So this can, for instance, be very important that once the legislation is passed already, parliamentarians can hold the government accountable for the effective implementation of the legislation. And then finally, another very important role, or the responsibility of parliamentarians, is their representation. So, of course, as they represent their constituencies, but they have access to public fora. They are public figures, so they can advocate for the abolition of the death penalty in any public events or any other means of representation. It is also very important to distinguish and to do, of course, the prior research as to the constitution, the governance of the state, to also know which part of the parliament or what forms of parliaments there are actually in each state. So, of course, this is applicable whether there is a federal state. It could be very conducive to target parliamentarians at both the federal level, but also then at a state level. If there is of course, national parliament is always the primary target, because I mean, in any setting, it's where the responsibilities usually would lie with those parliamentarians. But then, of course, we also cannot forget about, let's say, subnational parliaments or regional parliaments. And this could be particularly relevant. Of course, again, it depends on each state. But in some countries, the subnational parliaments are also quite autonomous. So they can actually pass the legislation which is applicable to the territory that they govern. So it's always very important to keep this actually in mind and in consideration. And the same goes for regional parliaments or sub-regional parliaments. And in particular, and in the African continent, there are numerous. So just perhaps to mention a few, it's the Pan-African Parliament, then the Eastern African Legislative Assembly, the South African Development Community Parliamentary Forum, ECOWAS, so the Economic Community of Western African State Parliament. So all of these, they can play a very important role in the advocacy. They can so they would be definitely also the targets to reach out to, let's say, after reaching out to the national parliaments. Besides the parliaments, there are also other networks or venues which would be of equal importance to include in any advocacy work. So this could be, for instance, a union of parliamentary networks. So at the global level, this is, for instance, the Inter-Parliamentary Union. At the African one, it's the African Parliamentary Union. And then, of course, several others at the Commonwealth. And again, the guide actually provides some of them and further examples. Other avenues, even relating to countries where, for instance, the death penalty has been fully abolished, but still, nevertheless, can actually play a very important role, is, for instance, the European Parliament. And having also worked with the members of European Parliament, I can say that it's definitely a very important. They play a very important role in their external policies and external affairs. So they are able to pass resolutions that relate to countries other than the European Union, and they have a very significant weight in this regard. Furthermore, if we consider parliamentarians in general, what their role is or why they should be a part of an advocacy plan, it's very important to keep in mind those four functions that I've just mentioned. But also let's say, in addition to them being the ones responsible for, let's say, lawmaking, they can also call on the government to include these issues, or maybe to encourage the government to take a position on their own. And of course, also in the countries where there would be already a progress towards the abolition, parliamentarians can also encourage other states to take any relevant action. So it's also important to look at them not only in the context of the national setting, but also, let's say, of their advocacy towards other states. The guide also provides some successful advocacy case studies, but I would let my colleagues to, and especially Noor, to speak more about those, because of course also they are better positioned to speak about their own experience and working with parliamentarians and actually achieving the tangible results and impact. So this is the first part of the guide, and now the second one explores a little bit more the ways how to work with parliamentarians. So first of all, how to start working with them, what the entry points are, what the advocacy points may be, how to let's say how to convince the parliamentarians, and then also how to maintain the working relationship. So what we have suggested to conduct for each NGO, for each member society to start with, is to do a very good also internal research of their own capacities of the civil society, each individually. And this has been done through a SWOT analysis, which basically goes further into analysis of the strengths of each civil society and its weaknesses, so the internal factors, but also the external factors, which would be the opportunities that they present to them, but also the threats. So further description of this analysis is in the guide. I will not really necessarily go into it, but it's very important to keep this in mind when setting the objectives of the targeting and of the advocacy, which is of course different in a country that has abolished, that has partially abolished, that has a moratorium, or that has still retained that penalty. It is always also very important, even though parliamentarians in general have very similar functions across the parliaments, it is always particularly important to do a research into in any responsibilities they may have, because sometimes this can differ. And perhaps also it's relevant to perhaps to some extent also mention these responsibilities to the parliaments, because maybe there is a scope of their work that maybe not, or let's say their mandate or their prerogatives that they are themselves not even aware of. And one of those, for instance, is visits to detention facilities. So sometimes it's very important that the civil society member is aware of these, and as such can actually present them if necessary, or be quick in being able to provide these. Even sometimes when the parliamentarian themselves are not available for a meeting, or they're busy, and they would, let's say, suggest to me their assistant, I would strongly encourage to always also go and to accept this opportunity, because also sometimes we do work with assistants, and it's the best way how to get to a particular member. And this is, of course, given their busy schedule, sometimes they also, it's the way for them to filter maybe the meetings that they themselves consider important. So in our guide, we present this also as a identification of allies and their networks. So this goes also to other MPs and also assistants or anyone else in the network of that particular parliamentarian. As a, for instance, example of political mapping, it's I mean, when we are supposed to engage with a parliamentarian, it's also very important. We are not able to engage with all of them, with the whole parliament. So for that reason, it's very crucial to identify which parliamentarians or parliamentarian, on one parliamentarian or maybe more, are of, let's say, there's a likelihood or high likelihood that they would be pro our objectives. So in our guide, we provide several criteria, or let's say points to take into consideration. So, for instance, one of them is to, of course, understandably to realize which political party the parliamentarian is from, and also whether they are a member of the majority or the opposition. Both can be of significant importance. Even, let's say, if the majority, obviously, they have much more leverage, they can and powers. But at the same time, the opposition can actually be much more vocal, and especially leader of the opposition is also in our case, our cases working with parliamentarians, sometimes they are very crucial in our advocacy, because they can really provide in the discussions very relevant points and not fearing to go against the majority. It is important to also research the particular committee that the parliamentarians are members of. So for the purpose of working towards the abolition of the death penalty, this would be obviously Committee on Human Rights or Justice, or let's say, as the theme of this year's World Day was a focus on women, there will be also, let's say, committees that are working with women's rights, which also could have an element of human rights perspective. Another criterion is constituency. So this would be also to see whether the particular MP may be coming from a more conservative constituency. Then, of course, this could be a little bit more problematic, or also just to in countries where there is relevant and there is a particular region that they represent. It's also very important to do research into this particular constituency that the parliamentarian represents. Another important point is to look at their educational background and their perhaps professional background. So again, as I mentioned, with the membership in the committees, this is particularly relevant for, let's say, human rights activists. I mean, there are exactly those parliamentarians that we want to engage with, as opposed to, let's say, parliamentarians who have much more, let's say, economical background. So this could be also very relevant to look into, as well as legislative track record. So to see whether the parliamentarian is active and whether there are those that would be engaged in discussions, opposing parliamentary questions, for instance. And then, of course, while doing the research, is to see whether there is any public statement that the parliamentarian has been making in favor of the abolition. That's, of course, or against. In that case, of course, it's better not to really engage with those and not to necessarily lose time. Again, on this note, the guide provides an example how important it was to do this political mapping in particularly large parliaments, where it was crucial to just to focus just on few members, and in particularly in Indonesia, for instance. And of course, as well as our continued engagement with the senators in the Philippines against the reintroduction of the death penalty. It is also very important to understand that parliamentarians are extremely busy. So it's sometimes also it's only conducive for the advancement of these objectives if the particular member of the civil society makes a good research on their timeline. So, for instance, if the parliament is not in session, they likely may not be responding. Similarly, if there is session on budget, for instance, our experience is that those are of such importance that just becomes absolutely priority. So it is more productive and much more constructive to be contacting and reaching out to parliamentarians in the moments, or let's say during sessions which are not of such crucial importance, for instance, for the governance. Afterwards, once this political mapping is, let's say, conducted, and also let's say the appropriate time or time frame is identified, it's also very important to think about how to actually engage with the parliamentarian. So identify the entry points. So how to actually meet or engage. And of course, if the civil society members are more vocal and they can broadcast their message widely and receive also a certain further recognition, this is only conducive, of course, to also gathering a little bit more of support and also being able to get the attention of those parliamentarians. Also, they could attend the conferences where the parliamentarians are present, or any rallies or, let's say, meetings of political parties. They can also try to reach out via social media, of course, with a caveat that sometimes the responsiveness, well, it may be difficult. Visit the offices could be, or scheduling a meeting is, of course, another direct way how to engage with them. Importantly, once speaking with a parliamentarian, it's important to really get their attention, given that their time span is very, very limited. So really making a very short pitch of all the advocacy points, and then of course having ready maybe something in writing for a potential follow-up. In the guide, we provide, let's say, a few of these tips, and also we go a little bit more into some of the even advocacy points, how to convince, or what would be actually good points to raise. And as an example, if there is a parliamentarian who is particularly concerned with minorities, it's very important to use a way on how to death penalty can actually negatively affect the minorities. So and this is the reason why political mapping is so crucial and can make a huge difference. Of course, any particularly important point is which would be case studies or country studies, or all of these further advocacy tools are just of great importance and can play a huge role. Once this, maybe as a kind of like a last point, once this the relationship with the MPs is, let's say, established, it's also very important to do the follow-up. And now again, parliamentarians are very busy. What may be a priority for them in that particular moment of conversation may no longer be, let's say, a week later. So it is without being unnecessarily too intrusive, it's very good to be following up with the MP through emails, or let's say any secure way of communicating. So for instance, we using Signal, or maybe some of these groups could be also, and keep engaging the parliamentarian, share news, information, or something relevant. And of course, organizing events or conferences, and be inviting the parliamentarian. I mean, we have several of other points in the guide that I don't necessarily have time to go through, but also one of the things that have been very important in our work, for instance, is organized parliamentary visits, if possible. Those are always to either relevant countries or institutions, and to really be engaging with also other actors than just those in their countries. The guide at the very end, after providing all these tips, also provides resources that can be actually used. So also several of the things on how to be convincing, let's say, or more advocacy points. They're all, let's say, in the fact sheets, statistics as well, which are very important to always mention. And also a template for a policy brief, for instance, if the civil society member would like to actually provide these to the parliamentarian. So these can be found at the very end of the guide. And I thank you very much for your attention.
Thank you so much, Frederika. That is essentially the guide, and there's so much to say about it because it is a very rich, detailed tool that tries to tailor different advocacy options with parliamentarians. So there's definitely a lot to go over. I would like to pass the floor to Honorable Dorcas Sibanda, a member of Parliament from the Republic of Zimbabwe who contributed to this guide and who will give us a parliamentarian perspective. Honorable Sibanda, if you can hear me, you have the floor for 15 minutes.
Thank you so much. Thank you very much. And 1,000 apologies for coming a bit late. Anyway, I will talk of, as a member of Parliament, the reasons why Parliament should be involved. Members of Parliament, of course, because of their busy schedules, still they have that oversight role. There are certain things which they have to taken cognizant of. Members of Parliament, they should safeguard the constitutions which in the Bill of Rights clearly states that everybody has got the right to life, which is very important. Therefore, when the NGOs, they should always take cognizance that members of Parliament should be involved in whatsoever way, in whatsoever time, in issues to do with safeguarding human rights, safeguarding the Bill of Rights in the Constitution. With members of Parliament, there's also need to advocate amongst themselves as members of Parliament, taking it back again to the constituencies which voted for them. Because whatever you do as a member of Parliament, it runs back from the constituents which voted for you. Therefore, when I look at the death penalty, when I debated it in Parliament, I also had to update the constituents to say this is what I'm going to do in Parliament and hear their views. So there is need to include the NGOs, the constituents. When I say constituents, I mean the ordinary person on the grassroots. They should also understand the reason why we say we need to work together with parliaments to make sure that such an issue like the death penalty is what is abolished. And members of Parliament also, I've noticed that in most cases, there is a need for awareness on their side as Parliament as well. Awareness campaign on them first before we could even talk of the constituents. For members of Parliament to understand, because some won't understand the reason why. Some have got, I mean, as human beings, we've got different feelings. One person will say, why should I say death penalty be abolished? Because I need to revenge, or because I'm in the ruling party, I need to make the opposition suffer, or it can be used as a political tool, you know, something like that. So, so there is need for them also to be, I mean, shown the way, shown the reason why we are saying the penalty should be abolished. So, like Frederika, it's only that I came in late, but I caught up with one or two which she good points. Like she was saying that there's also need to get targeted members of Parliament. It's a good point because in Parliament, there are different committees. We've got the Justice Committee, we've got that committee, maybe which is which is with human rights. We have got the Home Affairs Committee. Those are critical committees which should be targeted in Parliament. The parliamentarians who sit on those committees, Then they are also given what we call a working tool. Which will help them now to be able to explain, which will help them to see the reason why we are saying we should abolish the death penalty. Those are critical committees with critical parliamentarians. Anyway, any other committee will also be part and parcel of it, because if we say we look at those who are looking at women issues, because if someone is sentenced to death, there are hidden victims, the family. And that's where the women issues will come in, you know, that the women, the children will suffer because the father is being incarcerated, you know, things like that. So there is a need to look at those crucial committees, bring them together with the civic organizations, the NGO, you know, they should not advocate on their own. And also there is also need to get maybe the Ministry of Justice also. When I debated the abolition of the death penalty in Parliament, I also invited the Ministry of Justice. They were there, the technical staff, you know, to get the notes, to try and get everyone involved. It's also important. And as
Hello, Honorable Sibanda. All right, I think we might have lost the Honorable MP. Because I don't know if the other panelists can confirm, but I don't hear her. All right. Well, that was a shame because it was very interesting what she was saying and feeding in directly to the direct recommendations that the manual makes. You know, target committees, target areas where you think there's a place to interpret the question of the death penalty in those affairs. So for instance, you know, she had mentioned not only that women and you know, children can be impacted directly by, you know, maybe a father figure or you know, the main earner of the family if they're sentenced to death, but also as the theme of this year's World Day Against the Death Penalty highlighted, women can also be sentenced to death as well, and the impact that it can have on children who are left behind is also very dire. Perhaps so as not to lose any time, we will definitely catch up with the Honorable Representative when she gets back. But maybe what I will do for the moment is happily pass the floor to Ms. Noor Raja. So she represents Justice Project Pakistan, and who you know, contributed quite a bit of expertise and case studies to this guide. So Nora, I'll give you the floor for 15 minutes.
Thank you so much, Bronwyn, for the introduction, and also for inviting me to be a part of this crucial launch. It's a pleasure and a privilege to be in conversation with all of you today. So as Bronwyn said, I lead the policy and advocacy team at Justice Project Pakistan, which is an organization that represents vulnerable Pakistani prisoners facing the harshest punishments at home and abroad, and seeks to reform the criminal justice system. So I'd like to start off, I think, by talking about the broader question of why parliamentarians should be part of an advocacy plan. So I think just to preface, you know, my discussion, in most countries, I think the path to abolition has never really come through public opinion alone. It's always come through either the judiciary or lawmakers. And so it's intrinsic that parliamentarians as allies and key stakeholders are involved in this process. And so that outreach is necessary sort of from the get-go. And I think that they need to be equipped with the requisite data. They need to know what exactly the political costs of advocating for a particular reform or amendment would be, and then on the flip side, what the benefits would be. And so I think we as civil society organizations need to formulate a strategy and sort of show them a way to achieve reform on a key issue which is politically convenient for them, while also sort of approaching it from their perspective. But at the same time, I think that it's also important to know when to have parliamentarians, sort of advocating behind the scenes, and when it would be more conducive to have them come out publicly. So sometimes when the government of a particular country is not amenable to listening on a particular issue, the opposition becomes crucial in bringing that issue to the parliament's agenda by tabling a private member's bill or by asking questions in the relevant Senate and National Assembly committees. As JPP, in terms of our advocacy, whenever we work with parliamentarians, I think our approach has always sort of been, to push for smaller, more achievable goals, as opposed to asking outright for, a moratorium to be reimposed. Because we find that it's really those sort of incremental sort of movements and progressions that tend to be the most workable, at least within the Pakistani context. To tell you a little bit about Pakistan's application of the death penalty and what needs to change to sort of bring it in line with international standards, I'll just give you a bit of a brief background. So in December 2014, Pakistan lifted a 7-year moratorium on the death penalty in the wake of the tragic terrorist attacks on the Army Public School in Peshawar. And since then, Pakistan has executed more than 516 people, which has brought the country's annual rate of executions to the highest point in its history and has made it amongst the 5 most prolific executioners in the world. And although the implicit justification for the resumption of executions was to deter terrorism, most of those who have been executed were convicted of non-terrorism related crimes. So at present, Pakistan retains one of the largest reported death rows in the world, with approximately 3,831 prisoners. And in Pakistan, capital punishment is prescribed for 33 crimes, which includes various non-lethal crimes such as sabotage of the railway, assault on the modesty of a woman, perjury, and most of these, of course, do not correspond to the internationally mandated most serious crime standard. So even in the absence of an express moratorium on the death penalty, I think domestic advocacy with parliamentarians is an essential component of efforts to bring the government of Pakistan's application of the death penalty in line with international standards. And Justice Project Pakistan's evidence-based public and policy advocacy has sought to highlight cases of wrongful convictions of juveniles, prisoners with physical and psychosocial disabilities, incidents of police torture, and the plight of overseas Pakistani prisoners. So the case study that I would like to sort of elucidate in greater detail has to do with the Juvenile Justice Act of 2018. Pakistan had introduced the Juvenile Justice System's Ordinance in 2000, soon after it ratified the Convention on the Rights of the Child. However, since its enactment, the JJSO was marred by a lack of implementation and political will, and a major problem in hampering the course of juvenile justice is the dismal lack of birth registrations in Pakistan. As you may know, Pakistan has one of the lowest birth registrations globally. And it was observed actually in the concluding observations of the Committee on the Rights of the Child that only around 30% of children are registered at birth. So Pakistan's failure to fulfill the right to birth registration for its children means that the criminal justice system is then marred by a high risk of wrongful arrests, detention, and ultimately execution of child offenders. It was in 2018 that the Juvenile Justice System Act, or the JJSA, was promulgated, which contained a complete revision of the special judicial regime for juveniles to correct legal loopholes of the prior Juvenile Justice System Ordinance and to better adapt it to international legal standards. So in terms of our advocacy, JPP successfully held joint meetings along with child rights organizations and parliamentarians and conducted extensive advocacy to ensure the inclusion of age determination protocols within the Juvenile Justice System Act, which was a crucial safeguard which would then protect minors in the criminal justice system in a way that they simply had not been protected prior to this, as had been demonstrated before. So I think from our perspective, as a civil society organization, this was definitely one of the first sort of wins in which we conducted advocacy and were able to effectively incorporate, the inclusion of a priority area for us into, a matter of Pakistani domestic law. So I think the second thing that I would also like to talk about, is the issue of public hangings, which sort of continues to rear its head almost every few months in Pakistan, but also I think in the region as a whole, because the discourse around the death penalty for child sexual abuse and indeed sexual offenses in general, as you know, is propelled by this belief that there needs to be, harsher punishments stipulated for these offenses in order to deter them. So in Pakistan, since 2018, following the murder of a young girl called Zainab, there were widespread calls to severely punish perpetrators and to reinstate public hangings for them. And a Senate committee to look into the question of reinstating public hangings was convened that deliberated this issue. And I think that, again, for us became a point of advocacy where we were sort of able to, advise the relevant parliamentarians on what exactly this meant in terms of violating not just Pakistan's international obligations, but also indeed our obligations under our own constitution. So I think that's where, we were sort of able to, step in. And indeed, it is something that I think continues to gain traction every few months. And it's definitely something that we have been conducting ongoing advocacy for. Similarly, for the issue of Pakistanis who are overseas, we often try and attempt to bring their issues to the agenda of Parliament by formulating questions. And for the Senate, National Assembly, Overseas Pakistanis committees, and the Foreign Affairs committees, who can then raise those questions with the government and ask for responses to either questions pertaining to the status of consular protection, or to ask for data pertaining to Pakistanis who have been imprisoned abroad. So these are just a few examples of how we've been engaging in advocacy as a civil society organization in Pakistan. But I think one thing that I would like to talk about a little bit more in detail would be the tools that you can use to make inroads with parliamentarians. So in our experience, in terms of the policy and advocacy that we've been conducting, the first sort of point of contact that you have in order to generate the requisite level of interest for a thematic area that your organization has been working on is really, really fundamental. So that presentation, should be about only 3 or 4 slides. It should contain a great degree of infographics. It should be engaging. It should be succinct and, sort of really, really concisely lay out what the main, sort of problem is, and also what the main recommendation is that is being proposed to rectify the existing framework. And then once you've done that, that's when I think you can kind of go into the formulation and dissemination of a 1-page policy brief that sort of, lays down the thematic issue, provides very quickly and cogently both a policy recommendation and also a brief background on the issue, and also includes analysis that's been backed up by facts and data on why that policy recommendation will help solve the policy issue at hand. And then later on, for parliamentarians who wish to gain greater technical insight and background into the issue, you then, of course, have the option of formulating a longer policy brief. And I know, of course, that the guide that's been developed by the World Coalition and the PGA contains templates that would have a great amount of efficacy in developing these briefs. Another sort of strategy, I think, that's had great efficacy for us has been the formulation of relevant questions to be raised in Senate and National Assembly committees. So in the case of parliamentarians particularly, who are members of the opposition parties, what I find is that it's very effective for CSOs to keep them regularly apprised of all key developments pertaining to the application of the death penalty, as well as any salient violations of human rights, which they may be able to question the government on during public sessions of both the Senate and the National Assembly. So it might be conducive for CSOs to formulate a set of potential questions which parliamentarians may then be able to raise, which are, of course, of particular socio-political significance at the time. And then the questions that are raised in the Senate and the National Assembly public sessions also receive a high level of publicity and news coverage, which then, of course, has the potential to raise public awareness around the issue, in terms of the question that the CSO is advocating for. So these are just some strategies, but I think, of course, it's important to situate them within, the particular socio-political context that a particular CSO is sort of navigating. So, I mean, in the context of Pakistan, something that's been really useful for us has been the GSP plus mechanism, which is the framework of preferential trade, which has been implemented to a host of countries, and Pakistan is one of them. In return for compliance with 27 United Nations treaty bodies. And it's what I find is that it's very crucial to keep parliamentarians apprised of upcoming treaty body reviews, of any pertinent concluding observations that have been issued to the government of Pakistan, because it's now directly tied with the GSP plus mechanism. And there's a tangible, concrete benefit that accrues to the government of Pakistan, in adhering to these obligations and being in consonance with international human rights obligations. And so it's important, I think, to highlight exactly what these treaties are, exactly what the obligations contained in each treaty are. And then, of course, whenever Pakistan's subsequent treaty body review comes up, it's important to kind of keep track of those dates, maybe organize your advocacy around that, maybe get opposition parliamentarians to raise that particular question with the government in the lead up to a review, or subsequently after concluding observations are issued. I think that concludes it for my presentation. Thank you so much for the opportunity.
Thank you so much, Noor, for, this rich and illustrative cases that JPP has followed in terms of their advocacy strategy with parliamentarians. I think there are quite a few examples that hopefully participants can extrapolate from and maybe apply to their scenarios. I see that Honorable Sibanda is back with us. Thank you so much for joining us again. I would love to give you the floor to conclude and to continue your presentation.
Thank you very much. Where I am, there's a bit of network problem, so it's on and off. Please bear with me. So I was now saying members of parliament as lawmakers, they make laws, so they should be able to amend the same laws as members of parliament. So, but then when they do that, they consult the NGOs, the grassroots, they consult everyone, they consult the executive, they work hand in hand with the executive. So there should be part and parcel of involvement in such important initiative. But then there are also hiccups here and there, which will also be a drawback on them to be able to achieve their goals. So those are things which should be looked into as well. Resources, working tools, time, things like that. But anyway, in any case, I won't say much because most of the things I hear, they've been pointed out, which are necessary. But what it takes is that it's not every member of parliament who is going to understand an issue. So there is a need for workshops on them again as members of parliament.
I believe we've lost the Honorable MP one more time. I know how difficult it can be to have a reliable connection, and I will thank her for her persistence in joining us. And until she comes back and until she can take the floor one more time, I would actually like to take this opportunity to provide maybe some sort of wrap up, but really open the floor to the people who are listening and to those who have joined us in the audience, and to encourage you to ask questions. There's been so much shared today in terms of the overall structure of the manual, in terms of what specifically we can do to target parliamentarians that the Honourable MP had explained. And we have a wealth of particular case studies and examples coming from JPP as well. So I would maybe like to take this opportunity to open up the discussion and to please ask any questions you have to the panelists who are here today. And maybe as you're waiting, because we already received a question from Martin Mavindina, who's the who works at the Kenya Human Rights Commission. While you're thinking of your questions, he had asked, how can we ensure that members of parliament develop legislation that would completely abolish the death penalty in a different jurisdiction? So I don't know if there's a panelist here, if Noor or Frederika, you would like to speak to that question. How to go about ensuring the development of a very specific legislation.
Sorry,
Noor?
should I, yeah, okay.
Absolutely,
So,
yeah, thank you.
Yeah, so I think, it's really contingent on the socio-political terrain of the jurisdiction in question, because there are, of course, some jurisdictions where the death penalty is an Islamically prescribed punishment for certain offenses, which includes the offense of intentional murder. And, of course, it's a huge challenge, I think, to formulate legislation that's sort of all-encompassing and that would sort of cover, the entire list of offenses that would need to be abolished in order for the state to become a retentionist state. So I think I would go back to what I was talking about earlier, that it's really, for such jurisdictions, I think it's really about the incremental progressions that can be made. And it's about how you can, I think, sort of reduce the scope of the death penalty, not just, I think, in terms of reducing the number of offenses, but indeed also ensuring that there are particular categories of prisoners who are exempted from the death penalty, who shouldn't be on death row in the first place. So in Pakistan, like I've said before, that would include juvenile offenders, persons with physical and psychosocial disabilities, victims of police torture who have been, sort of tortured into falsely confessing to crimes that then go on to form the basis of their ultimate death sentences. So I think for us, at least in the context of Pakistan, it really has been about what, sort of those small scale movements can be, as opposed to, pushing for simply an all-out moratorium, because I think it really is about, highlighting exactly how the application of the death penalty is currently in contravention of international standards, but how it's also in contravention of our own constitutional standards.
Thank you very much, Noor. May I just clarify, Bronwyn, whether the question was relating to other jurisdictions, so not the jurisdiction of where the civil society is, but let's say I'm not necessarily sure I understand that point. If it's advocating in a different state or.
That's a good question. There's a bit, it's a little vague, and unfortunately Martin isn't with us at the very moment to specify what he meant. I'll read it one more time because I see the honorable representative is back with us. So the question is, how can we ensure that members of parliament develop legislation that would completely abolish the death penalty in a different jurisdiction? My understanding of that, question would have to be the jurisdiction in which they can pass legislation for. I don't know what a member of parliament could do in terms of legislating for a different jurisdiction. So I'm going to say that the question is more for the jurisdiction in which the parliamentarian is legislating for.
Because I was actually thinking that also, I mean, of course, it's not that the members of parliament could legislate in other jurisdictions, but they could be advocating towards this end. So this could be done either at the regional parliaments or through, let's say, the actors that I was mentioning and that are mentioned in the guide, which would be, let's say, either parliamentarians from completely different jurisdiction from the countries that have abolished. So maybe this would be one of the ways where actually the MPs could engage in different jurisdictions. I mean, because that is kind of like the first what I thought about when hearing the question. But then, and of course, as I mentioned, this could be, well, global events where they could be very vocal, or regional, sub-regional events. And so I could kind of see also the role of MPs in, well, trying to encourage the legislation in other countries through these means. And then, of course, when it comes to their own countries, then, I mean, of course, as Noor said, all of those points. And for instance, one of the concrete actions that MPs could take, for instance, is a parliamentary question, for instance, that could be submitted to the government, let's say, also to prepare the environment, also to inquire as to what the what is the kind of the opinion of the government on the topic. They could also, I'm just thinking in civil society, they could perhaps present arguments that it's in line with the public opinion. This is also something that the MPs would be kind of very inclined to take into consideration, because of course they want to always gather the political support of their constituency. And then once they I mean, they have to have a reason for that. And then to ensure the legislation, it's through, well, either presenting their private members' bill, or through trying to encourage the government to do the same through, let's say, parliamentary questions. So perhaps it's a little bit broad question in terms of what exactly it was, whether it was ensure in terms of advocacy from the civil society, or ensure through like which concrete actions the parliamentarians can actually take. But let's say all of this, I would say, like very in nutshell, would be going around the points that I believe that we have also explored in the guide.
Absolutely. I see we have another question asked in the Q&A section. So what are the main challenges in a retentionist country, even when the society agrees with the use of capital punishment? So I suppose this question is directed, when we say society, I'm assuming that you mean public opinion. So what happens, how can we go about approaching abolition in a country whose public opinion deems that the capital punishment should still be maintained? I might open this up again to our panelists if you have any ideas on how to respond.
Yeah, if I may. So I think, you know, Pakistan would definitely be an example of a country where there have been, you know, especially in recent years, in the context of terrorist attacks, as well as we spoke about earlier, in the context of child sexual abuse and rape, there have been renewed calls, you know, with increased vigor for harsher punishments, and indeed, you know, even for public hanging, not just for the death penalty. So I think in terms of, you know, sort of countering that narrative and providing an opinion, you know, that might sort of provide, you know, a sort of counter argument to that, I think there's perhaps two ways to do this. So I think one way, which I know that, you know, Justice Project Pakistan our sort of public advocacy has always been about humanizing stories. So we talk about the stories of individuals on death row, the systemic violations that they have faced, that have sometimes been exacerbated by existing vulnerabilities that they might have faced, whether these were juvenile offenders who were wrongfully convicted, whether they were persons with physical or psychosocial disabilities, who then whose condition was exacerbated while on death row. So that's one way, I think it's to talk about what the real tangible implications are for those people that we are ultimately sentencing to death, and the people that are currently on Pakistan's death row and who shouldn't be there. But another strategy that I think, particularly in terms of policy and advocacy, that I found useful has been the empirical analysis and statistical analysis of the deterrence argument. So in a lot of jurisdictions, the sort of main argument in favor of retaining the death penalty for a particular offense has sort of been to say that it deters the commission of that particular offense. But in Pakistan, I mean, we have multiple examples of offenses where this isn't the case. So whether it's around the issue of child sexual abuse and rape, if you look at the data around that, I mean, there's clear statistics not just from Pakistan but also from other jurisdictions like Iran and Saudi Arabia that do have the death penalty for these offenses that clearly show that it hasn't had the deterrent impact that it's been sort of been posited as having had. So I think these are two sort of strategies both in public and policy advocacy that have had efficacy in a social political context where otherwise it might be difficult to kind of talk about limiting the scope of the death penalty as a sort of like in terms of a blanket ban, if that makes sense.
I think the points mentioned, Noor, have been excellent and really think have covered, I would say, all of them, really the main points. Sometimes I'm thinking it's not only country that has retained the penalty. I mean, even in abolitionist countries, sometimes I would be facing this conversation, including in my own, and I find that, let's say, the arguments that I could see were, let's say, what would work the most were exactly providing the statistics of all the failure of justice, because that's just not, that cannot be acceptable and justifiable by anyone, because of course there is a lot of there is sometimes a certain voice, I mean, pro the death penalty by society in general, but the moment that there is actually a real case that had been let's say discovered, that has really a misuse of the penalty, I find that is something that could actually, and of course then making a story about it, I feel like this is something that could be used as one of the best advocacy points, because of course when we can speak about the financial implications, but still that is never as touching and as to the point and as really making it the case that this could happen to anyone. And miscarriage of justice is something that is of course present in every country. But even like the question was, what are the main challenges? Well, of course the challenges are even more broad and more significant than, as opposed to those where at least the society is in favor of the abolition. So of course, in terms of advocacy, I believe that one of very important points is also to take in consideration is to first to turn the at least the public opinion at least to some extent, and start, if possible, maybe with civil society on the ground towards this step, and then going up to the parliamentarians. Thank you.
Thank you, Frederika, and thank you, Noor. I have just one last question, I think, to wrap up this discussion, and it really speaks to, I think, the question of capacity of advocacy, which is already going to be dependent on the organization or on the individual involved. However, is it worthwhile targeting parliamentarians who are known to be pro-death penalty? We do spend most of our time, I think, as activists and as members of civil society in trying to find allies to our cause. To what extent do you think, and spectators, people who are listening are more than welcome to respond in your opinion in the chat box, but when and to what extent is it worthwhile to reach out to parliamentarians who might have previously had either a campaign or a platform or a policy that was pro-death penalty?
So I think, my answer to that, I think maybe very, very concisely would be, I think the only situation where that might be worthwhile would be where there has been, a legislative amendment or a bill that's been proposed that, aims to expand the scope of the death penalty to an area where it definitely should not be expanded, and public opinion, of course, might already sort of be swaying in that direction. But I think that when a parliamentarian, tables a bill that will sort of make that a concrete reality, or at least a legislative suggestion, sort of bringing it onto the agenda of Parliament, I think that's where maybe as civil society, we might step in, with empirical, analyses, with data, with statistics, sort of countering the efficacy of that particular legislative amendment. I think in my experience, that's definitely been one such situation.
In case that I would just also add, and thank you for this. Exactly as with every advocacy against, sometimes it also depends whether the parliamentarian is actually really against, let's say, the abolition as out of, let's say, his personal opinion, or it's just something that is aligning with the public opinion. Sometimes, again, they may have different personal opinion as opposed to what they actually are advocating for based on their constituencies. So, of course, in general, in our work, we always also target those parliamentarians whose, let's say, public statements are also against our objectives. First of all, it's also good to know the reasons, and perhaps sometimes a conversation with that MP can be actually quite relevant, as can reveal the reasoning or let's say the basis of that position, which is very important for further advocacy. But of course, also, who knows? I mean, it can trigger a certain point. I mean, it can perhaps through engagement, anyone could actually succeed in at least convincing the MP, or at least changing a little bit their position, or maybe highlighting a point that the MP did not necessarily think about before. So, of course, in terms of limited resources, that's of course a difficult call to make. But I would definitely say that it's always relevant, if possible, to also target those.
Thank you, Frederika. And to close out, a viewer has written kind of a case study, so I will read it for the recording. Curiously worthwhile, in Malaysia, found out one of the loudest MPs for the retention of the death penalty had his office sign off on a clemency petition for a death row inmate, and affirmed the thought that we had that he was just using the death penalty as a political tool. So that's very interesting, and thank you for sharing, this example coming from Malaysia, and really reiterates, I think, what we have mentioned since the very beginning, which is the death penalty used as a political tool. Well, thank you very much. I don't see any other questions for now. I really thank all of the panelists, Noor, Raja, Frederika, Schweighoferova, oh dear, one more time, Schweighoferova, apologies, and the Honorable Dorcas Sibanda, who I know had some technical issues in joining us today, but we do thank her for her time. So thank you very much to the participants and for everyone who joined us. And hopefully you will use the manual and it will serve you in your advocacy purposes. Thank you so much.
Thank you so much.
Thank you very much. Thank you.